Kia ora.
Lewis Wall.
Whawhitai, malo lava le soifua. It's been really interesting actually listening to some of the debate and reading some of the background information on this, the Electronic Monitoring of Offenders Legislation Bill, second reading. I'm not on the Law and Order Select Committee. I am part of our Justice team within the Labour caucus. And I was really fascinated by the Law and Order Committee commentary in the first page, which was all about, and I will read it, this bill would effectively restate and facilitate the existing ability to impose electronic monitoring as a condition of an extended supervision order on released offenders. So the reason it was highlighted was because the Attorney General said that this piece of legislation would place unjustifiable limits on offenders' rights and protections under the Bill of Rights Act, and the rights affected are those of freedom of movement against unreasonable search and seizure and against double jeopardy. And the reason everybody's become interested in that particular, I guess, impact of the legislation, Mr. Speaker, was around Tony Robinson, his offending when he was on extended supervision, and obviously the rape and murder of Blessy Katinko. And I can't not, in this contribution, acknowledge Blessy and her whānau and the impact of our justice system on their lives. There was an inquiry report that has just been released, and within that it said that there were issues in terms of the rehabilitation that this young man at the time did or did not receive. And so there are implications from that bill and that experience within our justice system for New Zealanders, and I think it should be acknowledged, Mr. Speaker. So the ability for people who are released from prison, a prison sentence of 2 years or less, now to be eligible for electronic monitoring actually is quite a big implication for our justice system. We currently have 4,000 people who are under an electronic monitoring regime, and there will be another 5,800 people that post this piece of legislation will be on an electronic monitoring regime. And it is an opportunity, I guess, to share what some of the submissions were to the Select Committee, and I too want to highlight Dr. Kim Workman's submission and acknowledge that he received a Doctor of Literature on the 19th of May this year, Mr. Speaker, from Victoria University, and that he's completing a book which is titled The Criminal Justice System, the State and Māori from 1985 to today. So he actually, on behalf of the Robson Hannon Trust for the Rethinking Crime and Punishment Project, did have some concerns. He said that electronic monitoring is the fashion, and his concern actually was about the rehabilitation opportunities for people who were in prison and then when transitioning out of prison into the community. And if the extent of the rehabilitation is now you are monitored and you have a probation officer who will monitor you in the community, if that's the extent of the support offered to those people, actually I think that there may be unforeseen consequences to this piece of legislation. Because what we do need to ensure, Mr. Speaker, is that anyone who qualifies under this regime actually receives the support that they need, drug and alcohol, other forms of counselling, and that part of the intent of this legislation actually should be to reduce recidivism. And so I'm not sure if that has been thought through as fully as it could be. I'm hoping that this is just not a cost-cutting mechanism, so that we don't have 5,800 people who should still be in prison released under this piece of legislation. But what I am reassured about, I should say, is that on our side of the House, we have a former Minister of Justice in the Honourable Phil Goff, who has been monitoring this piece of legislation. So because of his experience and his guidance of some of us on this side of the House, I too stand in support of this piece of legislation. Thank you.